diyah in Islamic law is the financial compensation paid to the victim or heirs of a victim in the cases of murder, bodily harm or property damage. It is an alternative punishment to qisas. In Arabic, the word means both blood money and ransom, and it is spelled sometimes as Diyya or diyeh. Diyya compensation rates have historically varied based on the gender and religion of the victim. Muslim women victims have typically been compensated at half the rate as Muslim male victims, while non-Muslims' compensation rates have varied between 1/16 to half of a Muslim for an equivalent case. Basis in Scripture. The Quran specifies the principle of qisas and compensation in cases where one Muslim kills another Muslim. It is not for a believer to kill a believer unless by mistake. He who hath killed a believer by mistake must set free a believing slave, and pay the blood money to the family of the slain, unless they remit it as a charity. If he be of a people hostile unto you, and he is a believer, then to set free a believing slave, and if he cometh of a folk between whom and you there is a covenant, then the blood money must be paid unto his folk, and a believing slave must be set free. And whoso hath not the wherewithal must fast 2 consecutive months. A penance from Allah. Allah is knower, wise. The hadiths, similarly, have numerous sunnah relating to Diyya. Narrated Abu Juhayfa. I asked Ali, do you have anything divine literature besides what is in the Quran? Or, as Uyana once said, apart from what the people have. Ali said, by him who made the grain split and created the soul, we have nothing except what is in the Quran and the ability of understanding Allah's book which he may endure man with, and what is written in this sheet of paper. I asked, what is on this paper? Quote, he replied, the legal regulations of Diyya and the releasing of the captives, and the judgment that no Muslim should be killed in qisas for killing a kafir. Narrated Hisham's father, Umar, asked the people who heard the Prophet giving his verdict regarding abortions. Al-Mafira said, I heard him judging that a male or female slave should be given as a diyeh. Umar said, present a witness to testify your statement. Muhammad bin Maslama said, I testify that the Prophet gave such a judgment. Jafar related to me from Malik that he heard that Umar ibn Abd al-Aziz gave a decision that when a Jew or Christian was killed, his blood money was half the blood money of a free Muslim. Application in Islamic law. Islamic law treats homicide and unintentional homicide as a civil dispute between believers, rather than corrective punishment by the state to maintain order. The offender must either face equal retaliation known as qisas, pay diyah to the victim or heirs of the victim, or be forgiven by the victim or victim's heir. In all cases of death, injury and damage, under traditional Sharia doctrine, the prosecutor is not the state, but only the victim or the victim's heir. Diyah is similar in practice to out-of-court settlement in a tort case, but with important differences. Under Sharia practice, tort like civil liability settlement is limited to property damage, while in the cases of bodily injury and death, the blood money diyah compensation is fixed by a formula. The victim's heir or guardian may alternatively forgive the bodily injury or murder as an act of religious charity. The value of diyah under all schools of Sharia varied with the victim's religion, sex and legal status. For a free Muslim male, the diyah value of his life was traditionally set as the value of 100 camels. This was valued at 1,000 dinars or 12,000 dirhams, corresponding to 4.25 kilograms of gold, or 29.7 to 35.64 kilograms of silver. The diyah value in case the victim was a woman, non-Muslim or slave varied in the Sharia of different schools of Islamic law. The diyah must be paid by the murderer, the estate of the murderer, In some cases, such as when the murderer is a juvenile, the diyah is owed by the family of the murderer. In other cases, the group that must pay diyah to the victim or victim's heirs is the tribe or urban neighbors of the culprit. For women and non-Muslims, diyah is not the same for Muslim women and Muslim men in Sharia courts, with Muslim woman's life and diyah compensation sentence being half as that of a Muslim man's life. Muslims and non-Muslims are treated as unequal in the sentencing process, in cases of unintentional deaths. In early history of Islam, there were considerable disagreements in Muslim jurist opinions on applicability of qisas and diyah when a Muslim murdered a non-Muslim. Most scholars of Hanafi school of Sharia ruled that, if a Muslim killed a dhimmi, qisas was applicable against the Muslim, but this could be averted by paying the diyah. In one case, the Hanafi jurist Abu Yusuf initially ordered qisas when a Muslim killed a dhimmi, but under Caliph Harun al-Rashid's pressure replaced the order with diyah if the victim's family members were unable to prove the victim was paying diyah willingly as a dhimmi. The Maliki, Shafi'i and Hanbali code of Sharia have historically ruled that qisas does not apply against a Muslim if he murders any non-Muslim or a slave for any reason. A diyah was payable instead. The early Hanafi and Hanbali Sunni jurists considered the payable diyah for Muslim and non-Muslim male victims to be same, while the Maliki school considered non-Muslim male's value of life as worth half of a Muslim, and the Shafi'i school considered it worth a third. The Jafari school considered non-Muslim male victims' value to be only 800 dirhams in contrast to 10,000 dirhams for a Muslim male victim. The compensation value payable to the owner of a slave by a Muslim murderer was the market price paid for the slave. The diyah for a murdered woman was half than the diyah for a murdered man in all fiqhs of Islamic law. Further, in Hanafi and Maliki Sharia doctrines, a diyah was not payable to a non-Muslim from a murderer's estate, if the murderer dies for natural or other causes during the trial. If the victim was Musliman, or an apostate, neither qisas nor diyah applied against the Muslim who killed the victim. Jurists of different schools of Islamic jurisprudence assign different values to non-Muslims. According to the Hanbali Sharia, the life of a Christian or Jew is worth half that of a Muslim, and thus the diyah awarded by modern-era Hanbali courts is half that awarded in case of Muslim's death. Hanafi and Maliki fiqh also consider the life of a Christian or Jew to be worth half a Muslim's life, but Shafi'i schools of jurisprudence consider it to be worth a third that of a Muslim. The legal schools of Hanafi, Maliki and Shafi'i Sunni Islam as well as those of Shia Islam have considered the life of polytheists and atheists as 1/15 the value of a Muslim during sentencing. Application in contemporary Muslim countries. Countries whose law follows the Sharia, including Saudi Arabia, Iran and Pakistan, also enacted laws for qisas and diyah. In Saudi Arabia, for example, the heirs of a Muslim victim have a right to settle for diyya instead of the execution of the murderer. However, the diyah compensation rights of Muslims and non-Muslims have varied among Muslim nations and remain unequal since the 1950s through the 2010s. The customary law of the Somali people also recognizes the obligation of diyah, but define it as being between subgroups, or mag, who may be part of different clans or even the same clan. Some of these countries also define, by lawful legislation, a hierarchy of compensation rates for the lives of people. Religious affiliation and gender are usually the main modulating factors for these blood money rates. Saudi Arabia. In Saudi Arabia, when a person kills another intentionally or unintentionally, the prescribed blood money must be decided by Sharia court. The amount of compensation is based on the percentage of responsibility. Blood money is to be paid not only for murder, but also in case of unnatural death, interpreted to mean death in a fire, industrial or road accident. For instance, as long as the responsibility for it falls on the accused. The diyah compensation amount depends on the religion of the victim. Human Rights Watch and United States' Religious Freedom Report note that in Sharia courts of Saudi Arabia, the calculation of accidental death or injury compensation is discriminatory. In the event a court renders a judgment in favor of a plaintiff who is a Jewish or Christian male, the plaintiff is only entitled to receive 50% of the compensation a Muslim male would receive. All other non-Muslims are only entitled to receive 1/16 of the amount a male Muslim would receive, while Saudi judges have the last say in any settlement. As of 2011, diyah price for a Muslim man in Saudi Arabia was State Route 300,004 an accidental death and State Route 400,000 in premeditated murder. Diyah in Saudi has been controversial, as in a 2013 case, where a father molested and murdered his 5-year-old daughter, but avoided jail by paying money to her mother. Iran. During the 4 Haram months, namely Dhu al-Qa'dah, Dhu al-Hijjah, Muharram, and Rajab, when wars and killings were traditionally discouraged in the Arabian Peninsula and later in the larger Islamic world, the blood money rates is increased by a third. In Iran, as in Saudi Arabia, the rates for bloody crimes committed against Iranian non-Muslims used to be half the rate prescribed for Muslim victims, but a change was enacted through a note to Article 297 of the 1991 Islamic Penal Code, authorizing equal blood money for the death of Muslims and non-Muslims. However, according to the 2006 U.S. State Department Religious Freedom Report on Iran, all women and Baha'i men were excluded from the equalization provisions of the bill. According to the Iranian law, Baha'i blood is considered mubah, meaning it can be spilled with impunity. In Iraq, the Bedouin tribes carry on the practice of demanding blood money, though this does not necessarily obviate the proceedings of the secular judicial system. Pakistan, which is predominantly Hanafi Sunni Muslim nation, introduced qisas and diyah ordinance in 1990, amending sections 229 to 338 of Pakistan Penal Code. The new ordinance replaced British-era criminal laws on bodily hurt and murder with Sharia-compliant provisions, as demanded by the Shariat Appellate Bench of Pakistan's Supreme Court. The Criminal Procedure Code was also amended to give legal heirs of a murdered person to enter into a compromise and accept diyah compensation, instead of demanding qisas-based retaliatory penalties for murder or bodily hurt. The democratically elected government of Nawaz Sharif in 1997 replaced the ordinance by enacting the qisas and diyah Sharia provisions as the law. Through an act of its parliament, the Sharia-compliant qisas and diyah law made murder a private offense, not a crime against society or state, and thus the pursuit, prosecution and punishment for murder has become the responsibility of the victim's heirs and guardians. The diyah law of Pakistan has proven to be controversial for a number of reasons. First, a number of cases of honor killings of girls, initiated and arranged with intent by families, have been later forgiven by the same families under the diyah law. Second, scholars have cited a number of cases of intentional murder and bodily harm inflicted on the poor by the wealthy, where the guilty escaped legal process and simply paid a compensation. Related concepts. Diyah notes that a concept similar to diyah was present in pre-Islamic Arabia, where it was paid in terms of goods or animals rather than cash.